SJC-12415, Commonwealth v. RB.
Mr. Campbell, good morning.
Good morning, Your Honors. May it please the Court. I'm Brandon Campbell for the petitioner. With your permission, I'd like to start with a discussion of the waiver issue because that seems to be what motivated the Court to take this case sua sponte from the Appeals Court. And I'd like to acknowledge the brief that was filed by the Committee for Public Counsel Services, the amicus brief, that was filed last week. And I think it gives a very good historical perspective of this waiver issue and establishes very strongly that the source of the confusion appears to be the McCool case from 2005, which really is an outlier. As a threshold matter, waiver, even in a civil context, is always subject to review where there's an issue about injustice. And I suggest that the more important analysis is not whether something is criminal or civil, but the weight of the interests that are involved. And certainly in the SDP context, with the deprivation of liberty, which can be as serious and in many cases more serious than in the criminal context, the interests are as weighty, if not more so.
So if you prevail on this, need we say anything more other than that where there is a constitutional liberty interest, then we will review for substantial risk of a miscarriage of justice? Must we go beyond civil cases where there is a constitutional liberty interest?
I think it would be sufficient with the liberty interest as it is, certainly, because people are facing confinement, certainly, from one day to life. It would be sufficient to say that. If the court were to try and carve a distinction between SDP cases and criminal cases, I think that the court would quite possibly create an equal protection issue in that criminal defendants who have an equal or even less weighty interest are entitled to more review than somebody who is civilly committed, who's not being punished for a crime. They're being confined for treatment and to protect the public, but not for punitive purposes, that there would be an equal protection problem there. And there's also some very, the Commonwealth makes the argument in their brief that, why should there be review if someone can file a Section 9 petition every year? And in reality, that turns out to be, they get a new trial every 3 to 4 years. What is happening right now in the lower courts is these petitions back up, and because there are not enough judicial resources applied to all of these people who are applying to get out of their treatment center.
I think the Superior Court would take issue with that last statement on the devotion of judicial resources, but the fact remains that they're not every year.
The fact remains they're not every year. Most of the petitions are adjudicated in a single session, unified session in Suffolk Superior Court, and with a backlog of 3 to 4 years. I would disagree, Your Honor, and I would hope that that's an appeal for another day. I would hope that that is an injustice that this court would someday look at.
I'm not going to quibble about the cause of that, but let's continue.
And with the respect to...
If I can turn you to the admissibility of the clinical records. Certainly they're admissible under 123 Section 6A in general, as a matter of statute. Agreed?
I agree.
And you're asking us to say that under some circumstances they should not be admissible, which that would have to be, I think, a due process claim, would it not be? It could not be, since there's a statute which says they're admissible.
It is a due process argument. It is an argument that these petitioners have a right to a fair trial before an impartial jury. And I'm also specifically asking this court to narrow McCool. I believe that McCool is incorrect, not just on the waiver issue, but in that it appears to establish that anything that is admissible under the statute, be that an initial civil commitment under 14C or in a petition for release under Section 9, they mirror each other, that anything that meets the statutory definition will automatically be admitted. And it appears that the Commonwealth argues that no matter how prejudicial, unfairly prejudicial, the information may be. And I would point out that the evaluation that we're talking about in this case, not only is it 24 years old, and put aside hearsay argument, that it is a youth who is 16 years old, who has documented psychiatric issues, who is not accompanied by an interested adult or an attorney, and considering that what we know about adolescent brain development, that this is something that should be looked at. This is an example of a case where reliability comes into question. And I would ask the court to...
Whose reliability? The reliability of the person writing down what the petitioner said, or the reliability of the petitioner?
I think it is more an issue with the reliability of the statements of the petitioner.
Okay, so then that's not hearsay, that's a statement of a party.
Yes, you can say it's a statement of a party opponent. You can say it comes in under the definition of as a medical record. But I'm asking the court to look past those things, especially where the experts in this case questioned the reliability of the documents. And the document itself, if you read it, the petitioner at that time, who's 16 years old, it says in there that he has an angry grimace on his face, that he's bored.
So what's the rule you want us to adopt?
I want this court to say that it is not simply a matter of looking whether a piece of proposed evidence is admissible under the statute, or under the statutory language, that in certain cases where reliability is in question, such as in this one, that the trial court has a duty to look at the reliability and weigh the probative value against the risk of unfair prejudice in order to ensure that petitioners receive a fair trial.
So that has to rise to a constitutional violation, right? Because the legislature can require the admissibility of evidence as long as it doesn't violate the Constitution, can it?
I agree with that, actually, Your Honor. And I think that in this situation, it does violate the Constitution when unfairly prejudicial evidence is admitted that compromises a person's right to an impartial jury.
So are you saying it's the same 403 analysis of balancing probative versus prejudicial, or are you saying it is a more demanding due process test?
Well, I think certainly the 403 balancing test would serve the interests of due process. So
Okay.
I think that would...
And under the 403, the judge has the ability to admit it.
I'm not agreeing that it would pass the 403 in this case, but I am arguing
You're
that...
saying to apply the 403 balancing, but it's doomed to failure in this
Yes.
case.
But what's happening right now because...
And that
of-
rises to a constitutional violation.
Yes, because what's happening right now with the interpretation of McCool being as broad as it is in this and other cases, everything's just coming in. And that's what I'm asking this court.
As the legislature wanted.
Actually, the legislature simply says that
It's admissible.
it shall be admissible. It doesn't say it shall be admitted.
So on your closing argument contention, the attorney said that these two QEs are credible, and then said why you shouldn't believe them, or why you shouldn't accept their opinion, correct?
And he said there were...
The concession that a witness called by the government is credible is grounds for ineffective assistance of counsel?
I think in the peculiar situation of SDP trials where experts are basically the entire testimony, and they are allowed to testify as to the ultimate fact, an attorney who points to two of those experts and says they're very credible, I think that that is a problem, and I think that is ineffectiveness.
Well, he didn't have much to work with. He had no
grant you that-
expert of his own, 3 experts against him. At least one of them, Dr. Joss, who we see more on the petitioner side than we see, I think, on the Commonwealth side. Doesn't he have to play the cards he's dealt?
I think he had cards that he could have played. Clearly, he could have argued the weaknesses in the probabilistic judgments that are brought to bear in this case and the science. You know, if it was a murder case and, you know, there's 3 precipient witnesses and defense counsel said 2 of them were in a better position to see the murder, so the third one, you know, shouldn't be believed, the defendant's still going to get convicted of murder. You have to argue that all 3 are not credible.
See, that's the rule you want us to adopt, that defense counsel or people defending petitioners can't concede things, that they have to just be rigid, say don't believe them, and the credibility of the attorney doesn't really matter when they talk to a jury.
I think that would be going too far. But
Because you know that a lawyer's credibility is on the line themselves when they talk to a jury in a closing argument.
certainly, and it's certainly an issue in these cases where frequently, and this one included, where you deal with some very, very difficult, horrible sexual offenses. And certainly, it is reasonable to make concessions, but a concession this broad, very credible, I think that that is beyond the scope of what is reasonable. And if you look at this error, which in combination with the other error, I do believe it had, that it materially influenced the verdict. Because we go from a case where we have a person who has one exceptionally serious governing offense to a person from the time he was 14 years old, he is he raped and almost murdered a young girl. So combining that and the failure of defense counsel to argue more strenuously that the QEs are not credible. And credible means convincing, that they should be believed.
I guess one problem I have is, one would think that your argument would be that counsel was ineffective for not providing an expert of his own to say that the petitioner was not sexually dangerous, but that's not your argument, which would suggest arguably that the attorney may have made appropriate efforts to find one and could not. So it's not as if he didn't challenge their opinions. He tried to in his argument. How do we get around the strange part that says he couldn't find or did not find anybody to testify as an expert in his behalf, and then he dealt with experts who had testified for both sides? What's he supposed to say?
I understand the point you're making, Your Honor, and would I have liked to have seen some independent experts on this side? Of course. But that is not, that gets into burden shifting, I believe, and I don't think it's the petitioner's duty to put on any expert testimony.
He has no duty, but it does go to the issue of miscarriage of justice. and as to whether this influenced the jury, since the jury didn't have a whole lot on his side to be arguing, as best I can tell, except for what the mother testified, I think, for him.
Well, yes, there were beneficial facts that the jury could have concluded he was not SDP. It was, if the one governing offense is viewed more in isolation and the other two is comparatively less minor, he was sorely punished for this offense. He was at an age where the risk of reoffense declines considerably. There were no disciplinary reports of a sexual nature. There were mitigating factors that I think the jury could have found that he was not sexually dangerous.
All right, thank you.
Thank you, Your Honors.
Mr. Frigo, good morning.
Good morning, Chief Justice Gantz. Good morning, Justices. Brendan Frigo for the Commonwealth in this case. If it pleases the court, this case raises two issues. There's an unpreserved issue of admissibility of the evidence of the juvenile psychological record generated as a part of the petitioner's DYS commitment, and also a question as to whether a strategically sound and frankly well-made closing argument consisted in effective assistance of counsel.
So you don't have any quarrel with applying a substantial risk standard?
Well, I was going to get to that next.
I think that's really why you're here.
Okay. So that's, of course, the court entered in the request for amicus, and I'll address that first. I think that in an SDP case, in a Section 9 case, because that was specifically the question in the amicus brief, in the amicus request, when the court is faced with an alleged error that is not preserved, I think you should start from the proposition that it's waived. There are several sound reasons to do that in this case. Obviously, there is in the statute this ongoing inherent continual nature of review for SDPs.
The issue that Mr. Campbell raised is a factual one in that there's a statutory right to yearly review, and as you know better than I, they're not yearly.
Well,
The cause of that is something that needs to be discussed at some point, but they're not yearly.
They're not. They are entitled to file a petition yearly.
Right.
They are not entitled to a yearly trial. This court in Trimmer in 1978 looked at the issues of speedy trial in these cases. And one of the things that they said, now at the time of Trimmer, the statute was different. It said that the person shall have a hearing every year. But this court said, no, what this means is that they're entitled to file a petition once a year. It's not a promise that you get a trial every year. What it is, it's a limit on how often you can file.
In your experience, what's the lag time?
It's about I think that's correct. It's about 3 to 4 years. Right now, Mr. Brown filed a new petition. The petitioner filed a new petition right after. He's currently scheduled for July of 2019.
So if a petition does all, and it's usually he, if the petition is all that he has to do and files yearly, the best we can do is every 3-4 years.
I think that's correct, given the way the there is a unified session. They go every week. There are limited experts in these cases. It's a very hard-working session, and a lot of cases are resolved in that session. But the lag time is about 3.5 years.
So you're saying to us, we should say, yeah, well, you had a crappy attorney. And yeah, there was a substantial risk of miscarriage of justice with regard to its finding of SDP, but it's only 3 years. And so we will accept it.
I don't think my argument is quite that callous.
Perhaps not how you would phrase it, but
right.
Isn't that ultimately what we would be doing if we were to accept your argument, is to accept the fact that a person who may have been a victim of a substantial risk of miscarriage of justice and may unjustly be serving 1 to 3 years in custody, who should not otherwise be in custody, and we should say, That's life.
Well, I think that this court has in the past, in Given and McCool and other cases, indicated that claims that are not preserved can be waived. And I think that they should be waived. Now, obviously.
And you read all the appeals court cases that were appended to the brief where the appeals court has assumed or has applied the substantial risk.
Yes, it's interesting. I think what has happened somewhere along the lines here is
In the footnote that.
right, in 2004, 2005, this court or 2002, going back to Dutiel, talked about waiving claims. And then, for some reason, in the appeals court, they've always kind of defaulted to the substantial risk standard. And I like to think about
Even in criminal cases, I mean, Randolph gets rid of this waiver analysis on the criminal side.
It does.
So, and defaults to a substantial risk analysis. So
It does.
So, I mean, it's not as if waiver is the answer to everything on this.
No, I wouldn't say that it is, but I do think that SDP cases are.
What I still don't get is what's the reason we shouldn't give a substantial risk standard?
I think if the court chooses to address the issue, then the substantial risk standard is the proper standard. And I think you should look at the Russell case as for guidance as to how stringent that standard is. And I would say that I think in the 60 some odd cases that I found the appeals court using the substantial risk standard, I think only one of them was overturned for substantial risk. And that one had multiple errors. But I think to answer Justice Kafker's question, I think that that waiver should apply because the person has, if a claim is waived because it wasn't raised below and there's no record for which this court and the appeals court can make an intelligent review of it, that claim is not gone forever. Instead, that claim can be brought back for the next Section 9, and the appeals attorney can talk to the trial attorney, and they could say, look, you need to make a record on this. And then the court would have an opportunity to rule, and you'd have an opportunity to hear what the Commonwealth says about the rule. Because in the CPCS brief, they seem to say that every time there's not an objection, that it's incompetence or inadvertence. And that's just, I just don't think, in my experience, that's the case. There's very often lots of very good reasons.
But don't we deal with this every day in criminal cases?
Sure, in criminal cases.
So it's not like we're strangers to applying this, or the appeals court is a stranger. The appeals court is actually doing it. It's not like it's this really unapproachable standard.
Right.
It's something that we do every day.
And I agree. And I'm just arguing that SDP cases are different, and I think that it's important to have a record on which.
But what about them
to make
is
your
so
decision.
different? What is the essential difference that you're looking at here?
The continual nature of review, the fact
That's
that
different than a Rule 30 motion on the criminal side?
it's, well, petitioners could file motions for new trial if they think their counsel is ineffective, and then that would allow them to build a record from which could be appealed, and then the court could then review from that record. Another difference is that in a Section 9, you're looking at the current evidence. You're always looking at the same question: is the person sexually dangerous at that time, based on kind of the person's whole life? With criminal cases, they get one shot. You're looking at a specific action or set of actions that happened in the past. And so it's just very different situations.
But in here, the issue, whether it's meritorious or not, is a different question. But here, the issue is whether or not that the record was properly introduced.
Right, and I think there's sound tactical.
And that's going whether it was or wasn't is beside the point.
Mm-hmm.
But that's an issue that ought to be resolved, correct?
Whether so you're asking whether this court should
Right, because you said
address that issue on a substantial risk?
Right, you said that these are new cases that
Right.
happen because we're looking, of course, at current issues, right?
Yes.
But that issue is always going to pop up as to whether or not that record was admissible.
I'm saying that the admissibility of a specific piece of evidence is very, very rarely. Remember, substantial risk is supposed to be for exceptional circumstances. Substantial risk should pop off the page at you. And just the admissibility of a single piece of evidence that was kind of brushed aside by the one witness who talked about it, that comes from a document that the statute says is admissible. The Commonwealth didn't really argue from it. That's never going to reach substantial risk. And you should be able to look at the claim itself and say, this is not of the timber.
I guess what I'm trying to get to, and you had said that there were 60 cases you reviewed where the appeals court used substantial risk.
Something like
and they were all affirmed.
Yes.
The bottom line is, what's the downside to our saying to the appeals court, go ahead and for us to use the substantial risk standard?
The downside is that you're going to put yourself and the appeals court in a position of making decisions without a full record. And I think it sets a dangerous precedent. For example, you don't know why there was no objection in this case. There's no record on it. You don't know what the court would have ruled. So if this court makes a ruling on this piece of evidence without knowing what the Commonwealth would have said at the time, what the court would have said at the time, then that's going to ring forward, and without any kind of record on it, because there's nothing to work on. Save it. Waive it. Say this is a waived claim. Raise it next time. Make a record, and then the appeals court can look at it. That's the downside.
But even if you're right, let's assume that we accept your argument that there's no substantial risk, then they just say counsel was ineffective for failing to object.
Okay, and then they should.
And McCool was decided before we applied the ineffective assistance of counsel standard in SDP cases.
Right. I would then say that the right thing to do is to file a motion for a new trial based on ineffective assistance of counsel and build a record there so that the appeals court can then look at it.
But we have said that that is the better way to do it.
The better, yes.
But not
Absolutely.
the only way. There are some errors so apparent on their face
Right.
that we would say counsel was ineffective. And isn't that about the same thing?
I do think it's about the same thing, Your Honor. But I also think that those type of things are going to jump off the page at you. I think substantial risk.
I understand. And again, it's a separate issue as to, issue one is, do we get to substantial risk? Issue
Right.
two is, does this particular statement rise to the level of a substantial risk? And I recognize that is a quite separate inquiry.
Right.
And probably we should move to that inquiry. Let us assume, for the sake of argument, that we say the fact that it's admissible by statute does not supersede the potential circumstance where it would be so prejudicial as to be a due process issue. What would you say our analysis would have to be?
Well, I think it would be, it would certainly, I don't think it would be the 403 that you mentioned earlier. I think it would be under due process. It would have to be of a constitutional dimension.
Doesn't it have to be more than 403? Because otherwise we're
Right.
ignoring the directive from the legislature.
Exactly. The statute has indicated a clear intention for these records to be admissible.
And actually, the SJC's decided cases where we've said that this stuff is admissible.
Right. Exactly. McCool among them, chief among them.
Would it be your experience, this is pretty much a routine record that was introduced and hence no objection?
Exactly. It's completely standard for experts to review DYS records, childhood psychological records where they're available. Again, this is another reason why, going back to my waiver argument, the record doesn't really say where these records came from, how they first came into the possession of the Commonwealth. But it is standard for people to look at this because it's required for experts to look back at the person's whole life, because a lot of these psychological traits that relate to sex offending behavior and sex offender recidivism go back to childhood, and they do in this case.
Well, your brother raises a somewhat novel argument that you couldn't look at the child needed to consult with an adult before he waived his privilege. What do you make of that?
I think if you look at the case that was actually mentioned in the petitioner's brief, I believe it's Alfonso A. He doesn't have to meet with an adult. This is a 16-year-old kid who has been in DYS custody. The record specifically says he was given the Lamb warning again, so he's had the Lamb warning another time. And I would argue that gives him the opportunity just the fact of the Lamb warning gives him an opportunity to speak to a concerned adult. He can stop and say,
I was just trying to understand as a practical matter how he's in DYS custody, right?
He is.
He doesn't have a parent that he can consult with.
Well, we don't have that from the record, Your Honor. We don't know that.
I'm just trying to figure out how it would work in the real world.
If there's an adult in his life that he wants to call, and he gets a Lamb warning, he can stop things and say, before we do this, I want to talk to whoever the concerned adult is.
Often when you're in DYS custody, there isn't an adult. you can talk to.
And I agree, but we don't have a record on that because there's no waiver here, because there's no objection here.
Now, am I correct that if we were to apply a due process standard, most likely the issues would come not so much for statements made by the petitioner himself, but anonymous or uncharged conduct based on arguably unreliable information about horrendous sexual conduct?
Right, which generally wouldn't come in anyway. Generally, the evidence of sexual offenses comes in if there's a conviction or an admission by the petitioner. I can't remember a time where I had evidence of something, but it wasn't a conviction and the petitioner says didn't happen, and I was able to bring it before a jury. It just doesn't happen. But when they say it happened, it does come in. And I would just point out that, like, the question of the reliability of the statements made when he was 16 years old, the issue is not really whether those statements were true. It's the issue is whether they were made. Because if they're true, that's one thing. If they're not true, it still speaks to the antisocial personality disorder because of the deceitfulness, because of the callousness that came in those statements. If I may, I see that I'm out of time. I would just rest on my brief with regard to the ineffective assistance of counsel claim. I think that he, as it was pointed out, he didn't have much to work with, and he used two experts to attack another on a very specific point. It wasn't in general, believe them on everything. It was very specific as to the sexual sadism diagnosis. And it was, he did a good job of threading that needle. So with that, thank you.
All right, thank you.